Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. I hope you guys are having an amazing day. This is a Diddy update. So, as I have reported in previous videos last week, Diddy has filed a new motion for bail. We went over, and this is the third one, by the way. And the government has opposed to that. We went over that. So now Diddy's attorneys has filed a letter to the judge. Let's get on into this one. All right, so today, this new filing was filed by Diddy's counsel, and it reads: Defense counsel has recently learned that the prosecutors are in possession of attorney client privileged materials, including the defendant's own written notes. This search and seizure are in violation of Mr. Combs' Fourth, Fifth, and Sixth Amended rights. Amendment rights. Let's get that clear. Moreover, the targeting of a pretrial detainee's work product and privileged material created in preparation for trial is outrageous government conduct amounting to a substantive due process violation. Because the prosecutors are currently in possession of privileged material, are actively using this material to detain the defendant, the defense requires immediate evidentiary hearing. This is emergent matter because the government has Mr. Combs' privileged notes to his attorneys concerning defense witnesses and defense strategies. Here's my thing. Based off of what was discovered in his cell, the written notes that pretty much had information that he supposedly written down when he got up in September, if those were privileged notes, you know, suitable for his case, I'm pretty sure he has seen his attorneys since then. It is November. You were arrested in September. Why don't you hand over that information to your attorney? Confused. And people may be like, well, he's getting ready for trial. And I definitely understand that. But any document, so if I request, and we have to think about this right now. He doesn't have access to a laptop. The only time, and so you're writing down what? Like I'm not understanding this. It'll be different if the attorney was giving him information like discovery where he has to answer questions and he's writing down the answers to questions. But anything as far as, written notes and all that other stuff, if you seen your attorney, why you didn't give it to your attorney? That's the biggest thing. So technically, in my opinion, I don't believe that is a violation of his Fourth, Fifth, and Sixth Amendment rights. Because at the end of the day, you can hand this information over to your attorney. When you meet, you can sit there and say, okay, here's my notes. Can you take them with you? So stuff like this won't happen. This can be used against you. Look at the Menendez brothers, where I forgot which brother it was, had a whole escape plan of how he was going to escape. Okay? Come on, Diddy. Come on. The government's opposition to defendant's bail motion states that the trial prosecutors are currently in possession of possibly privileged materials, such as the notes recovered from the defendant's cell. And that was on docket 69. We are that motion for bail package. Actually, we read the opposition from the government's regards to the motion for bail. In fact, the government is in possession of written material is absolutely privileged. This is a matter of grave concern that most respectfully most must be addressed immediately for the reasons. First, there is no dispute that the government is in possession of the privileged material. Second, until resubmission at 11:29 p.m. on Friday, November 15th, 2024, the defense has never been told that one, Mr. Combs' notes were taken from his cell, two, that these notes were given to the U.S. Attorney's Office, and three, these notes were then given to the trial prosecutor in this case, who then used this material in a filing to keep Mr. Combs detained. We request an immediate hearing at which the government shall provide answers to the following questions. First, who authorized the search of Mr. Combs' sleeping area, personal effects, and paperwork? Second, who determined what paperwork to take? Third, who decided to give this paperwork to the United States Attorney's Office? And fourth, who decided to give this paperwork to the trial prosecutors? Fifth, who made the decision to not tell Mr. Combs' counsel that the attorney was in possession of his notes, including possibly privileged material, until after the government put them in a filing to keep him incarcerated? Six, exactly what material was taken? Because the United States attorney, it seems the trial prosecutors are currently in privileged material. We request a full evidentiary hearing as soon as the court can accommodate us. I don't know what to say. Um, I really don't know what to say on this. I don't see that it is attorney confidential unless he was addressing it to the attorney or the firm was asking him to answer certain questions. Like if you're just on a piece of paper and you're just writing all this stuff, like I don't see that as attorney client privilege, because attorney client privilege is pretty that, you know, either our firm is sending to the client and the client is sending to us, but just jotting down things with no address to the firm or the attorney does not make that attorney client privileged. Now, if I say, turn over your, there's indicated, there's some instances, sorry, where in discovery we or I will ask, but mainly defense counsel will ask if, or whoever counsel will ask if you have notes or memorandums or diaries or things of that nature, and then that might be considered attorney client privilege. It just all depends. But I don't think anything outside of what's being addressed to, to Diddy or to the attorneys, anything outside of that is just stuff that we can use. It's not protected. So I'm very interested to see if the court is going to allow for them to have a emergency hearing for this. But I am interested on, the court's decision of whether or not his Diddy's paperwork or whatever you want to call it, his notes, is actually attorney client privilege, and if it actually violated his fourth, fifth, and sixth amendments. It's very interesting. Y'all tell me what y'all think about this in the comments below. Don't forget to like, share, and subscribe. Until then, be blessed, and I'm out. Bye.